10 USCIS changes that could impact your case before August 2025. Don't move forward with your immigration plans until you know what just changed. From marriage interviews to social media checks, silent denials to shorter work permits, USCIS has quietly rolled out some of the biggest shifts of the year. These are real. They're already active. And if you're not prepared, your case could suffer. Whether you're applying for a green card, renewing your work permit, or preparing for travel, July brought sweeping changes. Most of them aren't publicized loudly, but immigration attorneys are already seeing the consequences in real time. We're talking about rejections, referrals to ICE, and even denied entries at airports. Let's walk through the 10 major USCIS changes now in effect as of July 2025, and more importantly, what you need to do before August begins. This breakdown could save your application, protect your travel plans, and help you avoid costly mistakes in this fast-changing environment. 1. Marriage interviews are now deeper, longer, and more aggressive. USCIS officers are digging much deeper during marriage-based green card interviews. It's no longer just about shared addresses or wedding photos. Officers now ask about long-term goals, financial habits, family planning, and even how you handle conflict. These are future-focused intent questions, not just proof of past cohabitation. Couples who married quickly after meeting are under extra scrutiny. Officers are also pulling up social media accounts during the interview to cross-check information. If anything looks inconsistent, it can trigger a second interview, the dreaded Stokes interview, which is honestly much tougher and longer. This trend began quietly in July, and attorneys say the volume of second interview referrals has now doubled. If your interview is in August or September, you should really prepare with a mock interview. Honest couples can still fail if they're unprepared for how aggressive this has become. 2. Social media vetting is no longer optional. It's mandatory. As of July 2025, social media checks are fully operational for many visa categories. This isn't a pilot program anymore. It's real. USCIS and the State Department are now required to review social media profiles in several case types before making decisions. That includes F, J, and M visa applicants. Also flagged are certain H-1B and L-1 cases, especially if they're under national security review. Adjustment of status applicants may also be checked if there's anything suspicious or inconsistent in the file. This means officers are browsing your posts, likes, follows, and even meme activity. Private profiles or refusal to share login info can now be used as evidence of non-cooperation. Anti-American content or even satire could be misinterpreted. If you're filing soon, review your digital footprint immediately. Online activity is now immigration evidence. 3. No more 60-day window for medical forms. It's submit or be denied. Starting July 1st, USCIS made a quiet but brutal change to how it handles Form 1693, the immigration medical exam. Before, you had 60 days after filing your green card application to send in the form. Now, no more grace period. If your I-485 is filed without a valid medical, your case could be rejected immediately. There is no request for evidence, no second chance. You need to submit the I-693 at the same time you file the I-485, and it must be signed by a USCIS-approved civil surgeon no more than 60 days before filing. This small change is already leading to rejected green card applications. Don't risk it. If you're filing for adjustment of status, get your medical done first. Double-check the form. Make sure everything matches. Otherwise, you could lose your filing fee and start over. So, number 4. Work permits are now valid for only 6 months in some cases. Many immigrants applying for employment authorization documents, or EADs, are now getting approvals that are valid for just 6 months. Before, EADs usually lasted for 1 to 2 years. But starting in July, several USCIS field offices began issuing 6-month cards in key categories. This includes asylum seekers with pending cases, DACA recipients, and some spouses of green card applicants. It's not really clear if this is a nationwide policy or just a regional shift, but yeah, it's happening. Applicants are, honestly, being caught off guard when they receive shorter than expected approvals. A 6-month EAD means you'll need to renew way more often. That adds extra cost, extra stress, and, well, more chances for processing delays. If your card expires before your renewal is approved, you might not be able to work. So check your approval notice. Don't just assume your EAD is good for a full year anymore. And now, number 5, silent denials are on the rise for minor filing errors. Since June 10th, USCIS has really increased automatic denials for applications with small mistakes, like one missing signature, using an old version of a form, or even just forgetting a page. That's literally all it takes. And they won't send you a warning first. People are calling this a return to the zero-tolerance policy from the earlier Trump years. Even interpreters and attorneys must now sign their portions correctly. If anything is left blank or even just a little bit off, your case might be denied outright without a request for evidence. And honestly, what's worse is that the rejection doesn't always explain the issue clearly, which makes it a whole lot harder to fix and refile. So double and triple check your forms before submitting, especially if you're self-filing. The new error intolerance can really ruin your case before it even begins. 6th, denied cases are being referred to ICE more often. One of the most serious July updates is a revised internal memo from DHS. It actually instructs USCIS to notify Immigration and Customs Enforcement, that's ICE, when specific types of cases are denied. These include asylum denials, green card rejections involving overstays, and any suspected visa fraud. This doesn't mean you'll be deported immediately, but it does mean ICE can now be looped in a lot faster. Legal clinics in California and New York have already reported a rise in ICE letters being sent within days of denial. The coordination between USCIS and ICE is honestly growing. If your immigration history is complicated, don't wait. Get legal advice now before filing anything new. Even minor issues like prior visa overstays can now trigger much bigger consequences than before. Prevention is safer and, way cheaper than reaction. So, number 7, USCIS is now watching your social media long-term. Separate from the initial visa screening, USCIS has launched a long-term digital behavior tracking system. This is focused on permanent residents, visa holders under review, and green card applicants with open cases. It's not just one-time vetting anymore, it's ongoing surveillance. What exactly are they looking at? Posts that appear anti-government, satirical content that could be misunderstood, likes and follows of controversial figures, even sharing memes that appear political or critical of the United States could raise a red flag. One officer said anonymously, "We're not judging your politics. We're flagging behavior that could be interpreted as hostile. Whether you believe that or not, the outcome is the same. Your social media can now be used against you. So be thoughtful. Clean up your public profiles now." 8, more green cards are being approved under the 10-year rule 42B. Here's one piece of good news. Courts are overwhelmed, and that's actually opened a quiet window for more green card approvals under cancellation of removal, also known as 42B. If you've lived in the United States for over 10 years and meet strict requirements, you might qualify. You must prove continuous residence for 10 years, have U.S. citizen or permanent resident children, spouse or parents, and show exceptional and extremely unusual hardship if deported, and your criminal record must also be clean. So it's a high bar, but judges are actually showing more flexibility these days. Legal nonprofits in California and New Jersey are reporting a rise in successful 42B grants in July. If you think you might qualify, you should really consult an attorney immediately. The window could close quickly as court policy shifts, and honestly, don't wait until enforcement tightens again in Q4. 9 green card holders must now carry ID or risk detention. Here's a law that's always existed, but it's now being strictly enforced. Under 8 USC Section 1304, subsection E, all immigrants age 18 and older must carry proof of registration at all times. For green card holders, that means carrying your physical form I-551, your actual green card. In July, multiple lawful permanent residents were stopped at internal checkpoints and near state borders. They were held until someone could bring their physical ID. This is no longer rare. Officers are now being told to enforce this law aggressively. If you don't want to carry your actual card, at least carry a clear photocopy or an official USCIS digital copy. It could save you from hours of detention, or worse. Even a simple grocery run or a short road trip could lead to problems if you're unprepared. 10. The July visa bulletin surprised everyone, and August looks uncertain. The July 2025 visa bulletin brought surprises in both family and employment-based categories. F2A for spouses and minor children of green card holders is still current for most countries, but processing delays continue with wait times of 10 to 14 months in some regions. F4, the category for siblings of U.S. citizens, moved very little in some countries. It even retrogressed slightly. On the employment side, EB3 India moved backward by over 7 months. EB2 and EB1 categories saw no meaningful progress. This suggests that little movement is expected in the August bulletin. If you're waiting for your priority date to become current, prepare for delays. Keep your paperwork ready and follow each month's bulletin closely. Things can shift at any time without advance notice. So here are some final thoughts. Be precise, be prepared, be proactive. July 2025 really marked a turning point. The Trump administration's immigration policies are no longer just talk. They're actually taking effect quietly through subtle memos, training updates, and new procedures. There's more surveillance, more denials, and more coordination with enforcement agencies. But at the same time, there are still opportunities, especially for long-term immigrants who meet the right conditions. The system now is rewarding those who plan carefully, document thoroughly, and avoid careless mistakes. And honestly, it's punishing those who just assume things haven't changed. So what can you do before August starts? Triple check your forms, prepare your interviews, clean up your digital presence, and if anything in your case is complex, talk to a qualified immigration attorney. These changes are real, but with the right preparation, you can totally navigate them successfully. If this video helped you, don't forget to hit like, share it with someone applying this year, and subscribe to US Immigration Intel. We're breaking down the August visa bulletin and leaked DHS memos very soon. Stay safe, stay informed. See you in the next video.